the impact of technology on arbitration in China. As we know, the use of technology to support the practice of international arbitration has become increasingly commonplace. So is the case in China. Today, 5 speakers will share their insights on the topic from diverse perspectives. Before we start, please kindly keep in mind the mics of the audience be closed. To start with, I will give the warm welcome to Ms. Wang Weijun, Secretary General of SHIAC, to give the opening remarks.
Thank you, Suosheng. Good afternoon, everyone, and good morning to the audience from European time zones. I'm Wang Weijun, Secretary General of Shanghai International Arbitration Center. Today is a remarkable day for SHIAC and Jus Mundi. The 2 institutions are going to sign an MOU to enter into brand new cooperation. Meanwhile, we are happy to invite several experts to join our discussion online on the topic of impact of technology on arbitration in China. For the past few months, we kept close communication with the Jus Mundi team led by Mr. Jean-Rémi, the Maistre. We have meetings, of course, online to discuss our cooperation. What they have shown to us, including the well-organized website, the effective search function, and example cases which have been anonymized, convinced us their determination and capability to create a successful database. As far as I know, in recent years, Jus Mundi has become a rising star in the field of international arbitration. Up till now, its database of international law and arbitration has covered the range of investment arbitration, commercial arbitration, public international laws, and international trade law. The already posted cases on Jus Mundi's website were awarded by WTO, ICSID, various international commercial arbitration institutions, and ad hoc arbitration, which applied the 𝗦𝗽𝗲𝗰𝗶 rules. More importantly, Jus Mundi has concluded partnership with more and more influential international organizations and arbitration institutions. All these make us believe that arbitration information and the data could be used in a professional way to give the parties a clear direction when they choose arbitration. The past decade has witnessed the incredible development of international arbitration worldwide, and especially in the Asia Pacific. As one of the international arbitration institutions in this area, SHIAC also made great progress on its arbitration practice. With 30 years of development, the number of cases administered by SHIAC has been steadily increasing. Parties from more than 86 countries and regions have participated in arbitration proceedings administered by SHIAC. The awards of SHIAC have been recognized and enforced in nearly 50 countries and regions. The panel of arbitrators of SHIAC is constituted by 1,115 arbitrators. All the arbitrators come from 80 countries and regions around the world. There is a common rule which says, where there is a demand, there is a market. The frequent usage and high level of attention of international arbitration in China cannot be parted with the rapid growth of China's economy. In the same way, when we turn to the arbitration market, we also have to look for the demands of the arbitration users. In recent years, topics including third-party fund, arbitration diversity, virtual hearing, and the data security have been hotly discussed. As you may all know, the COVID-19 pandemic has significantly influenced the world in all aspects. In the year of 2020 and 2021, notwithstanding the impact of the pandemic, the case number and the disputed amount accepted by SHIAC still had a big rise. In the difficult times caused by pandemic, SHIAC promulgated the special relief arrangement for business entities to alleviate the economically distressed market participants. The special arrangement not only gave discount of arbitration fees, but also refund arbitration fees in successfully mediated or conciliated cases. On the other hand, in order to assist the parties in resolving their disputes efficiently and conveniently by using online arbitration services, SHIAC released the guidelines for online hearings. Nowadays, quite a few arbitration hearings at SHIAC are held online. As mentioned above, demands from the market and the users are certainly the external power to promote the development of innovation of arbitration. On the other hand, the internal improvement of arbitration mechanism is also important. As you all know, the confidentiality of arbitration is one of the most important considerations of arbitration users. However, the question of how to enhance the transparency of arbitration while guaranteeing the confidentiality of arbitration is worth mentioning. To resolve this seemingly contradictory question, many practitioners of international arbitration have made their efforts, including compelling arbitral awards, publishing arbitration data, formulating arbitration case guidelines, disclosing the constitution of arbitral tribunal. Within the annual reports of SHIAC in recent years, our institution has disclosed and publicized various kinds of arbitration data. Besides the basic business data, news, and events of SHIAC, we published the information of arbitration appointment, determination of jurisdiction, and revision of arbitral awards. We have done these jobs in order to enhance parties' understanding of SHIAC's basic information and common practice. In this way, I think Jus Mundi will become our important partner in establishing the database or platform for arbitration users. By sharing valuable and safe data, we would like to let parties formulate a more stable expectation of their arbitration proceedings. Under the cooperation mechanism between SHIAC and Jus Mundi, SHIAC was provided a certain number of awards, case analysis, and research reports. I really hope more and more arbitration practitioners will join us and contribute to their arbitration practice and experiences. Last but not least, I would like to give my special thanks to the three guest speakers today, Dean Jiang Huiling, Ms. Li Li, and Mr. Arthur Dong. Our speakers are all senior experts of judicial practice and international arbitration. I'm really looking forward to hearing their thoughts on arbitration from different perspectives. This is all for my sharing. I wish today's event a big success. Thank you.
Thank you, Ms. Wang. Dear colleagues and friends, thank you for joining us today. I'm Xiangshan from Jus Mundi. We are delighted to announce our partnership with SHIAC and honored to have such an all-star panel of experts and practitioners in international arbitration for today's discussion. Now I will give the floor to our special guest, Jean-Rémi de Maistre, the CEO and co-founder of Jus Mundi. Thank you for being with us, Jean-Rémi. The floor is yours.
Thank you, Shanshan, and thank you, Ms. Secretary General, for the kind introduction and invitation to speak today. It's truly an honor for us to build this partnership with you, and I'm sure it will be very successful for the coming years. I'm not sure everyone in the audience know about Jus Mundi, so I will go through a little presentation of our history, and also tell you where we go, what is our vision, and finally show you a bit of Jus Mundi online, so you can picture what will be the interest for users to have the awards published on Jus Mundi. So to start first with a little presentation. So today we will we're announcing this partnership with SHIAC. Jus Mundi, you probably not know us yet because we are quite a young company. We have been created a few years ago, and we have what we do is pretty classical at Jus Mundi. We help lawyers all over the world to have access to legal information, to case law especially, but also to information on professionals. And this is not very new, but for decades, we always use some services to have access to information. But what is new with Jus Mundi? It's first why we do it. Myself, I was an international lawyer before. I was representing governments in international disputes. And most of our team is composed of former international lawyers as well. And we do believe that it's important to make the international legal information accessible all over the world, so we can participate in building this international legal system ourselves as a legal community. And I really appreciate what you said, Mrs. Wang, that before, it's mainly the community, the arbitration community, that publish some information while protecting confidentiality all the time. But it always started from the community, and it's the same with Jus Mundi. And our goal is really to make this information as easily accessible to everyone, so we can spread the knowledge and reinforce the system. So that's why all the content, all the awards that are accessible on Jus Mundi are freely accessible. You don't need to pay to have access to them. And today we have more than 100,000 people every month, mainly international lawyers, visiting the platform, accessing the information, downloading it, etc. It's also why we did recently a partnership with Research for Life, which is part of the United Nations, and it's a program that makes information, resources, knowledge freely accessible to universities in more than 80 developing countries. And we participate in this program to facilitate also the dissemination of international law and arbitration information. The other point, which is a bit different about Jus Mundi, it is that we are a tech company. We are not a legal publisher. What we do is collecting information all over the world thanks to artificial intelligence. And we use this technology to extract the relevant information from these documents in order to build different kind of services. So I told you Jus Mundi is mainly composed of former international lawyers, yes, and the second part is mainly some tech and data scientist people who are working to make this platform possible. Most of us are based in Paris, so that's where we started in 2019, as it was said, on investment arbitration and trade law. And in 2020, we expanded to commercial arbitration. It was a bit surprising because everyone told us that, you know, most of the data is confidential. How can you build a search engine in commercial arbitration? So our idea was always, okay, let's try to collect everything that is not confidential so we can make information accessible to the community. And the first way for us to do that was to look into enforcement and set aside proceedings all over the world. As you know, in many jurisdictions, when you want to enforce an award, you have to publish the award. And so this award becomes public. And so we collected by ourselves, but we also did a partnership with the International Bar Association to build a collective network of lawyers all over the world to identify this arbitral award and collect them on Jus Mundi. That was the first step. And I want to clarify that when we collect this way, the award is available in full, because in most of the jurisdictions, the award is made public without redaction. But then we wanted to go further, and we had discussion with institutions, and what institutions told us is that we want to publish some anonymized versions, And if we have an anonymized version, we can publish, but the full award is not possible. So we developed an algorithm to redact also arbitral awards. And we did the first partnership with the ICC in 2021 in order to redact the award that they want to publish. And then with parties' agreements, the redacted version of the award is published on Jus Mundi. So now for all the awards rendered after 2019, the ICC is redacting the award and suggesting to the parties to publish them on Jus Mundi. We are a young company, but we are growing fast. We've been founding a few years ago, and now we are 70 people working to develop Jus Mundi already. We have opened a first office abroad earlier this year in New York, and we have concluded many other partnerships. The first one was with the 𝗦𝗽𝗲𝗁𝗍𝗂, which is the main US arbitral institutions. Then with the Hong Kong International Arbitration Center, with the Russian International Arbitration Center, and more recently with CBMA, which is a Brazilian arbitration center. We are in the process of opening our first office in Asia, in Singapore. It will be ready by the end of the year. And we look forward to further collecting information all over the world. Who is using Jus Mundi, in short? So it's approximately 300 clients all over the world. Most of them are law firms, let's say 75%. Not only big firms, we have both, like half is composed of the big firms and the other half is composed of arbitration boutiques all over the world. Zhonglun was our first Chinese client, so I also thank them for their support. But not only lawyers, it's also governments, mainly for trade law and investment arbitration, and also more and more in-house teams of big companies. So we have one in China. I don't have the right to use the logo, but it's one of the largest Chinese company operating abroad. In terms of maybe a few figures, because so you can realize how this use of technology is impacting the accessibility of information in commercial arbitration. Often we believe that there is more information available in investment arbitration because it's more public. Right, it's not the case anymore, and it's mainly because of Jus Mundi. You can see here that we have more than 5,000 today already arbitral awards that are full arbitral awards that have been published already on Jus Mundi, and it's growing very fast. More than 50% of these awards have been published in the past 5 years. So now it's really a game changer for the recent years. A lot of awards are published through one of the two sources that I described before. Okay. When you go on Jus Mundi, that's what you have as a homepage. So really, Jus Mundi is a search engine for which you can go and find as a resource. I was telling you that we collect already arbitral awards through enforcement proceedings. And I want to give you an example of a SHIAC arbitral award that we could collect through this source. So this is an award rendered in December 2013, and we could find this award because of a follow-on proceeding, a municipal proceeding after that happened in the following years. Okay, and in this case, we could collect the award, and the award is available here on Jus Mundi in full, and so you can read, download. If you do not have a subscription, you will find the same information and you can have access to the full award. Okay. So that's for when we collect by ourselves, and you see the name of the arbitrators are present, the name of counsel. It's part also of what we provide on Jus Mundi. I will come back to it in 1 minute. Now, so through the partnerships that we will implement with SHIAC in the coming days and months, the award that will be published will be redacted award. And I wanted to give you another example here. For instance, that's an ICT award that has been published through a partnership. And as you can see, a lot of information are redacted. For instance, the name of claimants, the name of parties. Sometimes a full paragraph are redacted because they can lead to the identification of the parties. So it's really a tailor-made exercise that is done for each case. Okay. And really the idea is to have the most valuable information online while protecting confidentiality. We really do believe that we can also that confidentiality is one of the most important features of arbitration, but confidentiality doesn't prevent us to publish some information that do not really have any impact on the parties. That's true for the redacted award, and that's true also, for instance, for composition of tribunals. There are more and more institutions that are publishing just the name of the arbitrators to prevent conflict of interest without any in-depth information about parties. Now, how will this be useful to users? Two very short examples. The first one that I wanted to show you, that's how users can interpret the rules of arbitration. So that's the SHIAC arbitration rules from 2015 that are available on Jus Mundi. And you can see on the right a little icon with 5. It means that we have 5 case law in Jus Mundi applying the SHIAC rules from 2015, okay? And if we go to a specific article, for instance, the article 22, and I click on the article, you see now 1. So it means that we have one case applying directly this article 22. And when you click, you can directly have access to the right paragraph that interprets this article. So for users, but also for the institution, it's very helpful to disseminate the interpretation of the rules that was made in past cases. Okay. The second very important part is when parties or counsel want to appoint an arbitrator. So the other ecosystem of Jus Mundi, which is called Jus Connect, it's more a kind of directory with information on arbitrators and counsel and experts to find who can be a good arbitrator for your case. And if you can use some filters here on the right to target some specific type of lawyers with a specific experience. For instance, if you want a Chinese arbitrator who has experience in commercial arbitration, you can target some specific economic sector, but you can also target someone who has already been appointed in a SHIAC tribunal. And then you will have access to some profiles. And when you open these profiles on Jus Mundi, you have all the information that we've been able to collect on these arbitrators, including some analytics on what they did in the past. This directory has become the go-to resource for most of the counsel around the world now to find information on arbitrators. And thanks to the partnerships that we've made today, it will make also this SHIAC arbitrators more visible. And so I just wanted to finish on this benefit of this partnership. For Jus Mundi, the benefit is, of course, to have more information from also Chinese arbitral tribunal available on Jus Mundi and from international cases that are decided in China. But I think also for SHIAC, the benefit is to make the work of the institution more visible, because as it has been said, SHIAC is now a very active arbitral institution, both domestically and internationally. So it will make this work more visible to the international community, but it will also make SHIAC acting arbitrators more visible to the community. And finally, I think it will enhance the accessibility of arbitration as a whole. So once again, I thank you for the trust that you put on Jus Mundi. We are very honored of this partnership, and thank you once again for the invitation to speak today.
Well, thanks for the introduction from Jean-Rémi de Maistre. Today is a big day for both SHIAC and Jus Mundi, since the MOU between two entities will be concluded. Now let's invite Ms. Weijun and Jean-Rémi, yeah, right, to sign the MOU and show the hard copy of the MOU in front of the camera. We are convinced that in the near future, more SHIAC's contributions will be accessible to legal professionals via Jus Mundi.
Now is Jean-Rémi. We have the SHIAC and Jus Mundi partnership agreement at hand. We are ready to sign the documents, which will bring non-confidential arbitration materials on Jus Mundi's platform for the benefit of global legal community to better understand the arbitration sector in China. It's a great moment for us to cherish, as SHIAC being the first Chinese arbitration institution who partner with us. We are confident that this phenomenal project will bring light to arbitration in China. Thank you. Thank you both, Jean-Rémi and Ms. Wang. And now continue with our panel discussion. I want to start by expressing my thanks to SHIAC again for organizing this webinar with us, and thanks to the panelists for agreeing to share your perspectives and wisdom on this topic. And finally, thanks to our participants. I know you're there even though I can't see your beautiful faces. There is a Q&A box at the bottom of the screen where you can submit your questions to the panel. Today, we are honored to have the distinguished Professor of Law, Huiling, Dean of Tongji University Law School and the former President of the National Judicial College of China. In his life before Tongji University Law School, Ms. Jiang served as a senior judge before the Supreme Court of China for more than 30 years. As particularly relevant today, Ms. Jiang has involved in Chinese judicial reform since the 1990s. He's a true witness, participant, and promoter of judicial reform in China. Let's get started. Ms. Jiang, I will turn it over to you to explain to our participants how much room is there for arbitration in China and why the development space, or as we say, the market for arbitration in China is still enormous.
Thank you very much, Xiangshan. It's really a great honor, and I'm very pleased to meet the friends online, old and new. Actually, we have met each other for more than 1 year. I think even we all are in Shanghai, the city, but the pandemic is really a problem. But it is really a great opportunity to speak here. Actually, I have learned a lot from the past 30 minutes of the Weijun speech and the Jus Mundi's. I cannot forget. I can pronounce the CEO's name correctly. I'm sorry, but Xiangshan is really a favor for me. But it's really great anyway to meet you. Well, I think arbitration as a part of the alternative dispute resolution in China or in the world, it's really a new to China actually. Although in the international perspective, the arbitration has more than 100 years history, but in China it's only after the new China, the 1949s, and especially after the open door policy. And actually, I joined the judiciary in late 80s, last century. At that time, actually, as a judge, the senior judge, I stayed in the Supreme Court for many years, 30 years, more than 30 years. So actually, at the beginning, I had no idea of the arbitration actually, since the judges always adjudicate, hear cases, judge those evidence, evaluate those evidence. This is very formal and decisive. What adjudication is binding, enforceable. But what is arbitration? But finally, after 30, 40 years, especially China has entered the time of the disputes increased very rapidly, dramatically. The court is full of burden of caseload. It's really a problem for us for the heavy burden on the court. And that is also why I joined the judicial reform team of the central government and the Supreme Court for numerous judicial reform programs. One is the alternative dispute resolution. But in Chinese, we call it 多元化纠纷解决, so we call it diversified dispute resolution, including the arbitration. So today I witnessed the cooperation of your famous institutions and the development of the arbitration business in the world, in other parts of the country. I'm really pleased. The topic of my remarks is really, it's very broad, but I think I just take these few minutes to articulate actually one point, and with some arguments based on my practice, experience in the Supreme Court, and the promotion of the diversified dispute resolution judicial reform project. First of all, China's court is really crowded now. You know that there are almost 10% increase of the caseload every year, and it's still in such trend. But the judges in China actually, 8 years ago, we had how many? 200,000 judges, but now we only have 130,000 judges. Since the judicial reform, we need to keep those more professional, competent judges in, but some of the old judges might be retiring or change their jobs to do some other things, and a lot of them go to the as lawyers, the legal profession. Actually, some of them. I also retired from the court as a law professor now, but actually, we do have more competent judges in the court system, but still, the number, the quantity is low, so it's still a very, very busy court. So that needs actually some helpers, some other assistant dispute resolutions. So in the Western world, it's called the alternative. Alternative, not major dispute resolution, but alternative dispute resolutions means to help or to reduce the burden of the judicial system. In China, actually, it is exactly the same, although we use the diversified dispute resolution, this term. Well, arbitration, as all of you know, especially Weijun is a true expert in arbitration. The arbitration actually, as I mentioned, when I just joined the judiciary, I had no idea of the arbitration. But now we definitely know that arbitration is a kind of we could call it a universal, non-governmental or unofficial adjudication or dispute resolution, since it's truly amazing because it's universal. All the countries accept that as a universal. It's not judiciary. Each country has its own model of judiciary. You have constitutional court, but we don't have. You have judicial review power by the Supreme Court, but we don't have. We have the National People's Congress Standing Committee review the constitutionalities of the legislation. So different countries have different models, but arbitration is almost the same, the universal. So that is also why it is amazing, so attractive to, and it's also why the enforcement, the recognition of the enforcement of the verdict, or not verdict, award of the arbitration could be accepted by 160 more countries to accept those New York Convention and put that into enforceable easily, much more easier than the judicial decisions by the state courts. But in China, since we don't have the tradition of the arbitration systems. That's new for China. So that's why we have, well, you know that in China we have around 290 cities below the provincial government, like Suzhou, like Yangzhou, those kind of levels, 290. But we do have 270 arbitration commissions around China. And we have 40,000, more than 40,000 arbitrators. Not so many, since in the United States, I learned that they have how many? 60,000 arbitrators for the, I forgot the name of the arbitration committee, but it's arbitration society like that. And we have, I think it's 400,000 cases each year, almost, or around that, in the past 10 years, almost in the past 10 years. So it share a lot of burden for the court, but it's still not as that big proportion within the judicial, the dispute resolution. But and we have some other. This is for the like commercial arbitration, but we do have some other labor arbitrations, and we also have labor mediation. I mean, we do have the people's mediation. That's another part, mediation, not arbitration. But those are all the alternative dispute resolutions for China, and the court relies a lot on those alternatives to reduce our burden. Well, actually, 4 years ago, the central government has issued a very important judicial reform document, action plan, actually, to promote the public confidence and the public trust of the arbitration system in China. It is, well, internal, external governance of the arbitration committees. It's quite an amazing one. It's after the, we have the arbitration law from 1995, but in the past many years, actually not nobody, but arbitration system is just developed for itself based on the 1995 law. Really very few concerns from the government to try to promote or to change that, to develop more. But from 4 years ago, 2018, and especially last year, early this year, last year, the draft revision of the arbitration law. That's really a big action. Although some people are still not satisfied with those revisions, but it has jumped forward for a big step. But according to the national policy, the reform plan, the action plan, I think the central government and those committees has taken a series of measures to improve some features of the arbitration system in China. First of all, is about the fairness or neutrality of the arbitration system. Since this is it's a kind of a life of the arbitration system, and also the independence, all the autonomy, this kind of self-government. So this is a very basic, one of the very basic features of the arbitration system. The second is about the professionalism. That is another so important thing. Of course, we don't see that the judiciary is not professionalized, which is also professionalized, of course. But the arbitration is putting much more on those parts, the professionalism. So people relying more on the professionalism and a lot of trainings, and especially I don't know what happened in Europe, in France, but in China from the last year, the Ministry of Education has launched the new program of the international arbitration degree something. Wow, that's a really amazing step. Well, convenience, friendship, that is another great features. And some measures also taken, like the online arbitration. Although I learned that from the SHIAC, Singapore International Arbitration Center, they have a webinar. They talked about that. Well, the online arbitration has a lot of problems, the concerns, but it is giving us more convenience. And another very important feature in China is arbitration system development. It's a systematically developmental. Since the court and the arbitration and the mediation and the attachment before the institution of an action and the decision making or arbitration and the judicial review and enforcement, this kind of line, it's like one stop in China. So this is also very important in China. Like the DDR system, DDR reform, like I have experienced, it's just to try to find out the connections between those different institutions, try to let them help each other to make these systems healthily moving forward. Well, the last one would be the internationalization. Well, although we have 270 arbitration commissions all over China, but well, not necessarily they all are internationalized. Some of those, like CTAC, like SHIAC, like well, BAC, the Beijing Arbitration Commission, those most competent, most famous and competitive arbitration committees would be attaching much more importance to the internationalization. So, well, as the national policies, we have B&R in the Greater Bay Area, or those kind of national policies. The arbitration system helped those systems, those policies a lot too. Well, I will conclude that aspect of the topic. Well, China, the arbitration system and the other ADR system they do have huge rooms for the market, for the development. And it's not only for the good for Chinese social governance, dispute resolution, but also for the international community of the dispute resolution. So that is what I want to share with you. Thank you so much.
Thank you, Ms. Jiang, for your wonderful speech. Our second speaker, an in-house expert, Ms. Li, who is the Director of Litigation and Dispute Resolution at HP Group in the APAC region. Ms. Li has significant experience in commercial arbitration, intellectual property law, civil and commercial affairs, as well as financial leasing. Ms. Li will talk about the development of science technology has improved the applicability and credibility of international arbitration. She will explain from both the arbitration institutions and the parties' perspectives.
Hey, thank you, Xiangnan. Thank you for your investigation from SHIAC and Jus Mundi. I would say that actually, Professor Jiang has already provided a very high level and a strategic review on China arbitration, which is really inspiring. And as arbitrator and also former judge and the current legal counsel from industry, I would like to share some of my thoughts from practical perspective. So we all know that the development of the technology in the past years has radically transformed our society and our daily life. And it also caused the profound impact on the international arbitration. And the adoption of various new technology has significantly increased the efficiency of arbitration organizations and optimized the workflow in management of the cases and also improved their capability to resolve the complicated cross-border disputes. For example, the e-filing of the cases, the video conferencing facilities. We all know that Zoom and Teams, etc., have been widely used in our daily work, and the online hearing. For example, the Shanghai International Arbitration Center has allowed the parties located in other cities or other countries to attend a hearing through video conferencing if the party cannot travel to Shanghai for the physical attendance due to the travel restrictions caused by the COVID pandemic or other reasons. Weijun, the Secretary General, just mentioned in her opening that in quite a lot of cases, the tribunal has used the online hearing. That's pretty true, I should say. In the cases that I act as an arbitrator, it appears that at least 30% of the cases during which one party did not attend the hearing in person. Definitely, this was approved by SHIAC, and also the parties had reached out to the mutual consent on that. Another example is that the SHIAC has also commenced this e-signature for all arbitrators, which truly accelerates the entire process. In addition to that, there have been many other technological tools used in the daily work, such as transmission of the legal documents. Nowadays, the associates can send the evidences submitted by the parties to the arbitrator through email, which seems to be very efficient. And as far as I know, not only SHIAC, but also all other arbitration commissions have adopted the new technology to facilitate their work. Last night, I have had the opportunity to observe a special ICC committee meeting. All those committee members based in different cities and countries, rather than in Paris, have joined the meeting through team system, and they have discussed and cases and issues and completed all tasks very quickly. I cannot imagine, without these technological tools, how long it will take for all these members to conduct the internal discussion, to review the case, and finalize those work. And finally, on the other hand, the development of the technology also had brought many benefits for the participants of the international arbitration. The use of the new technology has enabled the parties to be engaged in the arbitration proceeding following a very flexible, efficient, and cost-effective way. In particular, due to the COVID pandemic, people are getting used to the hybrid working style. Following Arbitration Commission's rules, the parties are allowed to join a conference meeting or the hearing from their own office or even from home. And they also can use their computer, the tablet, or even a smartphone to attend. This is really convenient and efficient for the parties. And it also, most importantly, I think it makes sure the arbitration proceeding move on appropriately without any delay caused by the COVID or other reason. Last but not least, in terms of the topic of today's volume, I need to mention that the technology used for the database, with the establishment and improvement of databases such as Jus Mundi, quite a lot of non-confidential awards have become searchable to the public, which has increased the transparency and the accountability of international arbitration. The CEO of Jus Mundi Jean-Rémi. Sorry if my pronunciation on your name is incorrect. Just introduced that Jus Mundi has applied the artificial intelligence to collect useful information and improve the entire platform, which is really advanced use of technology, I should say. In the past days, as Professor Jiang just mentioned, the public, even including the legal practitioners, the lawyers are more familiar with the court proceeding. And international arbitration seemed to be quite mysterious to the public due to the confidentiality. And in many contracts in the industry, we would see that people at the in-house counsel choose the relevant court to resolve the future disputes in the disputes resolution clauses. Now, with the expansion of the influence from the arbitration commissions and the improvement of the database, people would be able to access those non-confidential awards, doing research, taking the awards as reference, etc. And finally, they would find that the arbitration commissions are very justice, professional, and reliable. So as a result, I believe that more and more people and legal practitioners would prefer to choose arbitration as the main approach for disputes resolution. So now we are talking about the positive impacts and benefits from technology development. Definitely, the adoption of the new technology would also bring certain challenges and concerns for us from different perspectives, such as the security issue, the cross-border data transmission issue, etc. And due to the time limit, I would not address this anymore. But I'm sure Mr. Dong Arthur will share his valuable thoughts on these topics. Thank you. Over to you, Xiaonan.
Thank you, Ms. Li, for your speech. Our third speaker, Arthur Dong-xiao, is a partner at JunHe, who is a real professional in international commercial arbitration with impressive experience as counsel in cases covering international trade, cross-border investments, M&A, shareholder disputes, technology transfer, intellectual property protection, distribution, and franchise disputes. Arthur will share with us his insights on the benefits and challenges brought by the adoption of new technology into international arbitration.
Thank you, Xiangshan, for your kind introduction. Dear colleagues and friends, it's really my pleasure to be a speaker at this wonderful event. And again, congratulations to SHIAC, SHIAC, and Jus Mundi for the signing of the partnership agreement. Congratulations to both of you. The topic of my presentation today is the benefits and the challenges brought by the adoption of new technology in international arbitration. The benefits of introduction of new technology into the practice of international arbitration is obvious. We can see in the past years, especially in the past 3 years when the world is affected by the pandemic, the steps of adopting technology in arbitration become even quicker, just like SHIAC is what it's doing in the past couple of years. During the whole process of the arbitration, we can witness the effects of new technology, from the filing of new case to the service of the pleadings, from the provision of online repository to the arrangement of the remote hearing, even for the selection of arbitrator may be influenced by the new technology. Basically, I would like to very briefly summarize some benefits of the application of new technology in the practice of international arbitration as follows. First, it can promote the transparency of the proceedings. For instance, more and more arbitration institutions are beginning to encouraging the users to use a new service called Case Connect, just like HKIC and SIC are doing in the recent years. Case Connect is a digital case management platform that can connect parties, arbitral tribunals, and the secretariat of the arbitration institution. It facilitates case management in several ways. It serves as a permanent repository to which documents can be uploaded, circulated, including, for example, the applicable arbitration rules, the case written pleadings, and the tribunal's orders. I believe all of us have experienced that the situation that parties upload large size exhibits through the third party cloud drive, since they're too big to be attached to the email. But it's true that the storage of cloud drive may expire, and the parties may later dispute on what was exactly committed to the cloud drive. So while Case Connect, using Case Connect, we can avoid such potential arguments. Furthermore, users may receive automatic notifications when any file has been uploaded. The contact information of all participants in an arbitration are centrally recorded. Users can even track deadlines and dates on a case-specific calendar, which can be easily linked to Outlook. The progress of an arbitration can be traced with all activities in a case recorded centrally. This function is especially handy when any procedural schedule is adjusted by tribunal's emails instead of a formal procedural order, so anyone can track and check the correct deadline easily. So Case Connect is just one example among many tools which can promote the transparency of international arbitration proceedings. Second point, can promote predictability. As we know, confidentiality is one significant advantage of arbitration compared to the litigation before the traditional national court. However, due to the rule of confidentiality, it's hard for the users of arbitration to learn more about the arbitrators and the awards previously rendered. With help of technology, users can have more access to the background information of arbitrators, and it will become a reality that for the selection of an ideal candidate arbitrate, users may try to seek the help from algorithm or even by using the modeling software. Another practical tool is the database of the historical cases. Some arbitral institutions have begun to publicize the decisions and awards online after the sensitive information is redacted. By the help of such online database, users could have more predictability of the arbitral proceedings when choosing the arbitrators and to select certain arbitration institutions. As just introduced by Mr. Jean-Rémi Maistre, the CEO of Jus Mundi, I understand that it's just what Jus Mundi was doing and is doing, together with the globally leading arbitration institutions in the past years. Third point, I would like to say that by using the new technology, it could reduce the costs and the time for the parties. We all know that the arrangement of the on-site hearing is quite burdensome. Parties have to book the hearing room, which is not always available in the hot seat of arbitration. Arbitrators and parties need to apply for visas, to book air tickets, the hotel, and spend many hours for traveling to the city of the seat of hearing or the venue of the hearing. During the pandemic, attending an on-site hearing in another city or another country is even more tormenting, because in too many scenarios that there will be a requirement to go through quarantine when he or she back to his home country. But now with the visual hearing, this inconvenience could be avoided. At the same time, on another side of the story, when we enjoyed these benefits of brought by the new technology, we need also to take into account of the potential challenges and risks. The first point on this regard is that the data security, as our other speakers already shared their insights. For example, for the online repository, documents and information stored on such online platform may be extremely sensitive, and the consequence of leakage is not affordable to the user, to the parties. And even the practice of a multi-tier authentication system is widely adopted by the leading arbitration institutions. Nevertheless, it's still questionable that whether such measure is sufficient. And we look forward to further development of data security measures in the area of arbitration. The second point is that the confidentiality issue. Just take the remote hearing as an example. We can see so many third-party service providers are attending the online hearing at the same time. Just to give some examples that we can see the transcribers, the translators, online conference managers, IT support staffs, and so on. So how could we ensure these third-party service providers will also comply with the rule or the doctrine of confidentiality requirements? Another point, if I could say that, how to guarantee the quality of the hearing and eventually the quality of the award is still a noteworthy issue, especially when I think about that the arbitrate is hard to see the eyes, to see the body language of the counsel, especially the witness. It's also a challenge to the parties' counsel that if any technical issue happens during the hearing, we can imagine that while a great violin master is playing his concert, how it will look like if one string of his violin just breaks. Due to concerns with such technical issues, still there are many arbitrators or even practitioners prefer an on-site hearing compared with the remote hearing. However, it is clear that just like our other distinguished speakers said that the benefits of adopting new technology in arbitration overweight obviously the disadvantages. Apparently, these disadvantages, mostly are only some technical issues, would be finally resolved with the development and the improvement of technology. For instance, just the recent months, ICDR has announced a system in the case shield to be adopted. This kind of system is designed for arbitrators and mediators to provide a visual desktop, hosting documents and softwares in the cloud, providing a kind of enterprise level cybersecurity protection for case information, communication, and documents. We look forward to seeing more and more new technologies to be applied in arbitration, which will benefit the community by promoting transparency, efficiency, and to an even larger extent, and reducing the time and cost for the parties at the same time. Thank you all for your attention and your time. Thank you.
Thank you, Arthur. Now we have a question for Ms. Li. The question is, what is your experience with Chinese data export issues and other jurisdictions, if relevant, in offshore arbitration and litigation? Do you mind to answer that? Thank you.
Thank you. Thank you, Shanghai. Thank you, Susan, for your question. Actually, this should be a very hot topic in recent years, and due to the time limit, I cannot speak too much. Just briefly say that, okay, in the recent years, we have 3 important laws or regulations enacted in China, including the Personal Information Protection Law and the Internet security law and data safety security law, etc. So any cross-border transmission of data, including like this personal data, the sensitive commercial data, technology like know-how, etc., or any data regarding the public interest or national security should be very sensitive and should be reviewed and approved by certain authority if this data needs to be transmitted to overseas. So I have not seen any real cases in arbitration so far, but I understand that a lot of companies, in particular the multinational companies, have been improving their system, internal system, to comply with these laws and to avoid any risky of breach of any of the laws and the regulations in China. Okay. Thank you.
Thank you, Lily, for your answer. Now, I would like to turn it to Suosheng.
Okay. Well, thank you, Xiangshan, and the three guest speakers. Thank you for your sharing. You have shared us with the overview and the potential of arbitration in the ADR market in China. Analysis of the arbitration is empowered by technology. I think Jus Mundi is keen on the cutting-edge sectors and topics, so that's SHIAC. And Jus Mundi provide a platform for the users to acquire the knowledge, but also a platform for the arbitration institutions as SHIAC, to display our professionalism. So SHIAC is pleased to announce the cooperation with Jus Mundi and willing to share the materials and the knowledge with the international community. So thank you for all your attention.
Thank you, Suosheng. Thank you to our panelists for this fascinating discussion, and thank you to all our participants. We wish you have a great day.
Yeah, thank you. Have a good day.
Thank you. Have a nice day.
Thank you.
Bye.
Thank you.
It was a pleasure.
Thank you.